the purpose of today's conversation specifically is around discussing informed consent, discussing disclosure, and discussing record keeping, and trying to not get too lost into the legal detail of it. So the legal detail is always a deep interest for me. So when I got into practice and I wondered why all of this was happening, and I don't know about all of you, but in the 90s, certainly in the late 80s and early 90s and mid 90s to the early 2000s, medical litigation is not what it is now. It's a lot more aggressive now than it ever was. And so I then went back and I studied my law degrees, and then I did work with the Law Society, the South African Medical Legal Association, to try and understand this. So I'm going to try and blend this in a way that makes sense and is relevant for our practice. And I want to start with a statement. I don't like the term medical negligence because I don't believe that that is true. We have medical professional indemnity in the same way that others have engineering professional indemnity or legal professional indemnity and so on. You will very rarely hear me talk about malpractice because I don't believe that malpractice is there, but I do believe in patient safety and patient safety incidents. And we know from our own practices, and we know from research, and we know from collaborations and colloquial work that 1 to 24 patient safety incidents per 100 consultations. That's quite a lot. It means that 1 in 4 patients may or may not have a consultation-related risk to them. And a consultation-related risk is something that could put the patient at risk, and the patient at risk could be because of an adverse outcome or because of a lack of follow-up. And we bucket that into 2 large buckets. A risk because of something we do, which we call an error of commission, like a medication error, something that we've physically done. And more difficult are the errors by omission, the things that we leave out, our failure to take the right action. And taking the right action could be taking the time to have the conversation with the patient around their risk or around the procedure or around their options. It may also be the tasks left undone. And a task left undone could be record keeping or obtaining permission to share information with disclosure, or as a result of incomplete disclosure. And that could happen sometimes because of the patient's issue. It leads to missed care or gaps in care. And both those errors of omission and commission can lead to lapses in quality of care. Now, I don't know where exactly you sit in your care, but one example of this would be you see a parent, primary caregiver, who comes in with a child, and you and the caregiver discuss consent, and you discuss what needs to be done, and consent is confirmed, the other parent is absent. And it turns out that the parents are acrimoniously divorced from each other. And the one parent takes exception that they weren't part of the consent process. And so that may lead to an error by omission or an error of omission, because you haven't had the conversation with both parents, which you're not necessarily obligated to do, but which is often necessary. So we are measured, and we're not going to talk too much about that today, but it is a good start. We are measured by 2 tests. Us as the reasonable practitioner, what would us as the reasonable practitioner do? We're not expected to be the perfect practitioner. And we, in our own minds, expect ourselves to be the perfect practitioner. So every time I see a patient, I say, have I been as thorough? Am I as good as I could be? And then afterwards, I worry that maybe I haven't been, or maybe I wasn't as clinically robust or attuned as I could be. But equal to that, there's the patient's obligations. And I know all of you love reading the Health Professions Council Ethical Guidelines book. It's only 380 odd pages. But what I would point you to is the patient's obligations under Chapter 3 of the Ethical Guideline book. And the booklet speaks specifically about the Patient National Rights Charter, what your patient is obligated to do in continuing their care, in being respectful of care, in following up of care, and in fully disclosing. So when we talk about an error by commission or an error by omission, I do want to say right up front that this is a dual set of circumstances that aren't only driven by the practitioner. They are often driven and made much more complicated by the minds of the patient and sometimes of the extended family of that patient, who can make life quite challenging. So jumping into today's conversation, and what we're going to do, it's 10 after 6 now. We're going to speak until about 5 to 7 and pause and take some questions. So there is a concept of consent, which we know about, and consent is an expression of will by any person. That is the dictionary definition of consent. We're going to talk about consent in terms of the National Health Act principally, and the National Health Act is subordinate to the Constitution and the Bill of Rights, specifically the rights to privacy, the rights to autonomy, the rights to control of one's body. But underneath that, when we talk about the National Health Act, of which our registration with the Health Professions Council is subordinate, and then the ethical guidelines, which are subordinate to that registration, we do have to recognize that there are very specific statements. It's an offense to provide a health service to a user without the user's informed consent. And then that asks the question, what defines informed consent? Because if consent is an expression of will by any person, the issue of how a person is informed becomes one of this big issue of consent. And then also how you record that consent, how you manage that consent after the fact, what happens with that, and that'll take us then into the record keeping. But when we talk about consent, some of the work that has informed us in South Africa is legal precedent that comes out of common law, which comes out of the European Union, it comes out of the United Kingdom, and it comes out of the USA. There's a discussion on what's called meaningful consent. And it asks these questions. What personal information are you collecting? With whom will it be shared? Now, how often when you take informed consent, do you say to your patient, it is likely that this information will be shared with other caregivers in a multidisciplinary team, with other healthcare providers, including rehabilitative specialists, including nurses, and including other persons who may need that. Then you need to say, what purposes is this information being collected for what purposes is it being used, and for what purposes is it then potentially being disclosed? Now, this again becomes important if you have a multidisciplinary team around the theater table. There's a big discussion right now as who owns the patient record and who owns which piece of the patient record. A lot of effort is being placed into saying, can we create integrated medical records? And I'll disclose some of my background on that. I chair the organization called Safe Surgery, where we're working very hard with FOSAS and other members about this. And CASASA, which is the Body for Quality Health Standards, is asking the same questions. These are the non-profit views on how we can improve quality of health. But that then comes into how we obtain this meaningful consent. And then the final thing is, what are the risks or the harms or other consequences of the data being collected and then potentially shared? And that's why today's conversation, where we talk about the principles of consent, is linked very carefully to medical records and very carefully into disclosure. So at this point, I would ask you, how good do you believe you are on your informed consent? You may think you're rock star brilliant. You might feel that you could do better. You may be taking notes on pen and paper. You may be taking notes electronically, but an unbiased or an unambiguous question to you to consider, and what we should have done, and your colleagues earlier before we started said, we should ask for polls, and I should ask you now, and you can think and reflect for yourselves, what kind of consent form do you use? Do you use a digital form? Do you use a written form? Is it completed prior to your first consultation by the patient when they're in the waiting room? Are the general consents done before the patient arrives? Are your procedural consents done with your consultation? And then how do you record those consents? So I use this, this story of Dr. Mark as an example. This is a clinician who was diligent, who had a conversation with their patient. They explained to their patient what the issue was. The patient took a frivolous position and said, well, you didn't tell me enough, and you weren't fair enough, and you weren't clear enough. And they found a personal injury attorney who was willing to advocate this with them. This colleague spent 2 weeks in court giving evidence. Now, to give you a context of what that means, A day in court is roughly 150,000 Rand. He spent 10 days in court, and that excludes the at least 40 days of preparation that happens before that. One of his comments was he felt alone and that there were no colleagues around him until after the trial. After the trial, he was found not to have been negligent, not to have been wrongful, and to have not been in dereliction. He was found to have done a really good job. But during the time until he was found by a judge, not of his peers, but a judge of the court of law, that he was actually absolved, he felt alone and without support. His lessons were this, and I'm sharing this with you because this comes into the principle of consent. And it does come out in the ethical guidelines. Informed consent is the entire therapeutic experience, doctor-patient experience. It's not just the document you write. It's the conversation you have with that patient during your examination or during your therapeutic journey, which includes your procedure, includes sometimes your admission, your pre-surgical journey, your post-surgical journey, your discharge, and your follow-up. So that's informed consent. And everything that you do during that time is aligned to that informed consent. So your safe practice management strategy and your operating procedure is a necessary part of that. So you need to understand that if you haven't got written down what your safe practice management strategy is, what you communicate on and when, how you communicate, and what your standard operating procedure is. If I said to you, prepare a stack of documents for me for tomorrow morning that the patient signs, that the patient reviews, and the journey of how you go through your diagnostic assessment to get to your diagnostic opinion. Can you do those documents? And if you can't, that is part of your practice preparation that would lead you to a level of not clinical excellence, but practice management excellence that we often find is lacking when we need to defend somebody on a patient complaint. And then the third lesson that came out of this was you need to recognize and manage post-traumatic stress disorder. When we talk about COVID at the moment, a question that I was asking earlier is how many people are on the front line as first-line consultants. And one of the things that we're finding, and there's less good studies on healthcare providers, but the studies on patients is up to 35% have a deep, persistent anxiety disorder following their diagnosis and symptoms. Now, any person who's been through a challenge, and I don't say a lawsuit, but certainly through a challenge around their clinical efficacy and whether or not they did informed consent or whether or not they did harm, has a tremendously stressful journey. So be mindful of those three things. Everything you do and say to the patient forms part of informed consent. It should be consistent with your practice management strategy. That's a documented strategy. And you should identify both in yourself and ask your colleagues, peers, office administration staff, spouse, loved ones, to tell you if you're starting to exhibit signs of post-traumatic stress. And then we get into what does informed consent mean? And this is a whole different creature. When we start looking at informed consent, we look at the National Health Act, specifically the legal requirements for consent. We'll go through those in a little while. It's Section 6 and Section 7. We also need to understand that in the Health Professions Act, Section 53 talks about financial consent. So your consent is not only your legal requirements to let the user, your patient and their family know about what is going to happen, but also what the costs will look like. So I'm pointing you to a couple of areas for reference. The first reference is Section 6 and 7 of the National Health Act, Section 53 of the Health Professions Act, all read together with Booklet 1, specifically for Section 4.6 on your natural duties and moral obligations, including your institutional and legal duties. Also applying the principles of informed consent as an ongoing process. And the reason I put this here is because people say, well, I saw a patient, I got consent, and we're good now, right? And I said, well, when did you see them last? Or when did you see them prior to this consultation? If it's longer than 6 months ago, or if it's for a different condition, they might have come in and given you consent for a specific condition at a specific time. But if there's a new condition, even if it's the same condition with a different procedure or other intervention, you need to redo that informed consent process. And then we spoke earlier, and I'm just reminding you back on booklet 3 of the National Patients' Rights Charter. And the booklet about seeking patients' informed consent is booklet 4. So it's good to know that you've got the 3 things there that I do think that you should have: the details of the condition, the details of the investigations that may or may not be needed and the treatment options that come with that, and the details relating to cost. You also have to give a reasonable patient the alternative. So you say, here's therapy A, B, and C. Here's the benefits of therapy A and B and C and D. Here's the harms and here's the risks. And ultimately, it's the patient's decision, not our decision as a practitioner. It's the patient's decision which therapy and procedure they elect to go with. And recognizing that is a significant shift. And I'm going to raise 1 or 2 judgments, which I think are important judgments. But we went in a case by Castile, which was regarded in medical terms what was called the locus classicus case. It was a case that related to whether the patient was properly informed about the procedure that would be done to them. And that moved from what was a mindset of what was called medical paternalism. It's our responsibility as the practitioner to decide what the patient needs to know. And that was informed by a case in the United Kingdom called the Bolam case. Subsequent to that, subsequent to Castile, and this is 1994, so we're going back a long time, but subsequent to that, patient autonomy took more of a front row than medical paternalism. And the reason that's important is because it was viewed that if you didn't give informed consent, the wrongfulness of your behavior was considered in the light of an assault versus a negligent act. Subsequent to all of this in 2015, there was a case in the UK, which is the Montgomery case. And the judge found at that point, and this is in keeping with our discussion now, that the patient should be told whatever they want to know, not only what the doctor thinks they should be told. And it's that the reasonable person in the patient's position would be likely to attach significance to the risk. So it's not only now what you as the practitioner, who's a reasonable practitioner, thinks is important, it's also what the patient would be likely to attach significance to. And you can see the reference there, which is the British Medical Journal. So for those of you that would like these or have an interest in this kind of theory or case law, you're most welcome to do that. And I'm happy to share this information with you. But here we go into the practical applications of informed consent. And to inform is to tell somebody about specific facts, and their consent is to agree to do something with that or to have something done to them. So there are 11 key things to this. And the doctrine, and I'm not going to murder the Latin as we go through this, is to a willing person, injury is never done. And that's important because if you're not doing injury to a willing person, you have to recognize a couple of things. What you're doing must be recognized by law, and it mustn't be against good morals. The consent has to be given by a person capable, meaning they have to have intention and understanding, and it has to be free and voluntary. This becomes more complicated when you're dealing with a person under the age of 18 and over the age of 12, because they're the issue of how precocious the child is, whether they can understand the implications or not, and the influence that their parents have on them and their religious beliefs have on them become very important. They also have to have a knowledge and awareness of the nature and extent of their harm. They need to appreciate and understand the nature of their risk, and they need to consent to that harm or assume that risk. The reason that I'm bringing this up with you is I'd like you to reflect now and say, how much of what you share with your patients in their consent journey reflects what I'm bringing out for you here. The consent must be comprehensive. And there was a point where the HPCSA stated that you needed to declare a risk if there was a 2% chance of it materializing as an adverse outcome or as a complication. That's come down to 1%. If there's a 1% chance of this materializing, the patient needs to consent to it. They need to understand it. It needs to be clear and unequivocal, preferably in a graphic and oral and written form so that they can understand it. Then what you have to be aware of, that what they're consenting you to do has to be a legal act, and what you do may not exceed the consent given. There's a lot of issue that's had where a patient says, yes, I agree that you could go and you could have a look and you could do A, but while I was sedated, not only did you do A, but you also did B and C and D. And those areas were outside of consent. So you need to be able to work with your patient in a collaboration in a manner that says there may be a need to do additional things of A, B, and C. Should that occur, I need your consent now that this could happen. And, you know, it's a nice theory. We call these things theory because they don't work in, they don't work in practice. But one also has to recognize that there is a manifest challenge to being able to get what I call dynamic consent. So static consent is your general consent, and you can sit down, you can say to the patient, this is how my practice works, this is how my disclosure works, this is how my bedside manner is, this is my payment style. But when you start doing a procedure and things become fluid, being able to move through that is a very important exercise to do. So when we define informed consent, we define it in terms of security in and control of one's body, which is a key series of phrases in the Bill of Rights. And it relates to sections 12.1c, to be free of all forms of violence from either public or private sources. I mentioned to you earlier that there is a consideration subsequent to that locus classicus case, that when you remove that freedom from violence by not getting consent, your action could be considered as an assault on the person. And in doing so, you then limit their rights to bodily integrity in terms of section 12.2b, which is bodily and psychological integrity, including the rights to security in and control of their body. So when you start doing consent and continue to do consent subsequent to today, and the reason that this is an ethics talk and not a clinical talk is because the theory of consent is that the user should have full knowledge in order to understand what needs to be done. And here you can see on the right-hand side of the page that you must inform the user of their health status. And then there's except in circumstances where there's substantial evidence that in doing so won't be in the best interest of the user. Now, how do you work out whether this is going to be in there or outside of their best interest? And there's often urgent interdicts and appeals to the court where a practitioner or a group of practitioners believe that a procedure is in the best interest of the patient who doesn't believe the same. But also recognize that the user needs to understand that they have the rights to refuse health services. And you need to be able to explain the implications of the risks of that refusal to them. So you need to ensure that when you do this, you're doing it in a way that the user, which is the patient or the person consuming the health service, and or their family who represents them if they're not in the capacity to represent themselves legally, have the information given in a language that they understand. And that doesn't mean it's English or Afrikaans or any one of the other 9 official languages, Zulu, Xhosa, or isiSotho, or other, but it is in a vernacular that they understand, because we spend years learning the Latin terms for complicated things that we don't always translate back into a manifest understanding that people may have. So a person's level of literacy is important. I see there's no questions coming through, so I'm just assuming that everyone is delighted and following this and all is good right now. I do know that if there are questions, you'll let me know. So bear in mind that in terms of defining informed consent, in terms of section 7, it must be given in a number of forms. The consent must be obtained except if the user is unable to give consent. And consent is then given by a person mandated in writing. Now, consent can be given in a specific order by the spouse or legal partner of that individual, by the parent, and then the parent, the grandparent, or an adult child or brother or sister in that order. So in the event that I can't give consent and I haven't given an advance directive or given legal consent, that consent needs to be given by a significant person who is able to do so, failing which the court can give consent, and sometimes the court can override consent of others. And separate from that, if failure to treat will result in a serious risk to public health, we've all experienced this in the last couple of months on COVID-related issues, or if treatment for any reason delayed could result in death or irreversible damage. Then we get into the issues of Good Samaritan involvement, roadside assistance and care. That's a very delicate one. So I'm going to hold up my wrist and say, this is a form of an advance directive. This is a like a medical alert badge. And one of the things on my badge is what I want done in the event that I can't speak for myself. So you need to be aware that your consent needs to be given by somebody with capacity to do so. And what is your style or your practice in the event that there is a refusal, either from the individual and or from a family member? Do you refer out? Do you maintain the care? Do you have a counseling referral with a psychologist to discuss the treatment requirements? This can be a complicated issue. And further, it's complicated because it's your responsibility under Section 7.2 of the National Health Act to take all reasonable steps to obtain the user's informed consent. Now, the key legal words here, and I bring these up because I think it's important on the ethics side that we discuss this, is what does reasonable mean? You would have to be able to show that you met and exceeded the reasonable person test, that somebody with the same training as you in the same circumstances as you would do to achieve consent. Doesn't mean the perfect steps to obtain the consent, but it does mean the reasonable steps. And Section 7.3 goes on to define consent as consent for the provision of a specific health service given to a person with legal capacity to do so, and who's been informed as per how we've been discussed. So you can't say, well, I've done one consent for everything and everything I do. Consent is specific for a health service. And often we find that a person says, yeah, well, I was going to do A, so I got consent, but then I changed my mind or circumstances evolved and I needed to do B to stabilize so that I could do A. And then the patient comes back to light and they say, well, this isn't okay. And I had a case like this recently where the gentleman called me and he said, you know what, I'm really grumpy. I said, why are you grumpy? He said, I'm in pain. I said, we went in for an inguinal hernia repair and he was expecting mesh and he was expecting A, B, and C, but he woke up and there was 2 stitches and that was it. He said, what kind of surgeon did this to me? I said, well, what did the surgeon say to you? He said, well, the surgeon said, I'll do it if it's needed, but how do I know if it was needed or not? It's been 2 days and I haven't seen the surgeon. So at that point, there's a tipping point that happens in consent. This patient is either told this is perfectly normal, it's okay, the surgeon is doing a great job, you've got stitches, you didn't need a mesh and everything is great, or the person says, you know what, that was a terrible action and I know a lawyer who can help. And if it goes the second route, the difficulty is whether your records are sufficient to show that what you did and what the patient understood were the same thing. Because it's not only what you do or what you write down, it's also importantly what the patient understands. So this all began in terms of our world in a case called Stoffberg versus Elliott. So this is relatively contemporary in medical law. It's only 98 years old. But it says any bodily interference with our restraint of a man's person, which is not justified in law or consented to, is a wrong to that person. So anything that you do to another person needs to be consented to. You've heard me speak about the Castile versus de Greef case from 1994. And then this goes on to say in Lawrence, the question was raised as to what degree the risk should be disclosed. And there was a judgment in 1976, you'll see it on the left-hand side of the page, that says, at what point do you say so much that you scare the person and they don't want the procedure at all? So sometimes you're disclosing enough to galvanize the patient to action. Sometimes you're scaring them into action, and sometimes you're doing the opposite. So you have to walk a fine balance. But ultimately in McDonald versus Rowe in 2006, this is the key thing, is no informed consent represents a violation of the patient's right to bodily integrity. Now, I've left that as plaintiff's right, because once this reaches the courts, it's no longer you versus me. It's plaintiff versus defendant. You lose your rights to identity at that stage. And then that becomes a very difficult issue. And it becomes a difficult issue because if you look at the cases in front of you, and you look at the South African Law Reform Commission, you need to understand that the average lawsuit that can't be settled and agreed upon in a relatively polite way takes 7 years. Can you imagine what 2029 will look like after 7 years of internecine war? And I call it internecine war because both parties get damaged during that. So I'm not going to talk about the Mental Health Care Act other than to say that you need consent to care. And you need consent to care in terms of the different types of users. So if you are working with users where there is a risk of harm to themselves or others, your approach to getting voluntary consent versus assisted consent versus involuntary related consent speaks to different areas of that act. It's not for today's conversation, but it is suffice to say that when you're thinking about consent, you're also thinking about it in terms of the Mental Health Care Act. So then we talk about the ethical rules. What is the main responsibilities for us as it relates to consent? The first is we need to respect patient confidentiality. We need to respect patient privacy. We need to recognize it in terms of their choices and their dignity. Now, that includes you. If you were the patient, what would you want? But equally, there's a tension because notwithstanding the fact that we need to provide this confidentiality and privacy, we also have to provide adequate information about the patient's diagnosis, what their treatment options and alternatives and costs are. And sometimes we have to provide that to people who are not the patient. So the patient needs to exercise a choice, but sometimes the patient's family needs to exercise the choice. And so you'll see in section G, it says, except in the circumstance, you need to obtain informed consent from a patient, or if they can't, from their family or kin. So the 4 golden rules of consent, for what they're worth, is obtain consent from the person legally competent to give it. Bearing in mind that if there is a child involved, be cautious to approach both parents because they might not be in consensus and agreement with each other. The second is obtain an informed, keyword there, informed consent. Make sure that it is clear and unequivocal, because what I think I'm agreeing to and what you are going to do might not be the same thing. And then obtain comprehensive consent. A lot of complaints that are raised against practitioners are because of a non-comprehensive or incomplete consent. Yes, I've got consent to do A, but you didn't tell me how much it was going to cost. Or you didn't tell me that I was the one who would have to pay for it. Even though it's clear and it's not ambiguous, you need to have a comprehensive consent. And at this point, I would ask the question for you to consider, do you have a copy of the National Patient Rights Charter that you give to a patient or that you have up on your wall and you point and you say, I'm responsible, I'm your clinician. I carry a heavy burden in looking after you and providing you therapeutic interventions and procedures. But you also have an obligation, and ethical, social, and moral obligations. We call them ESLIs, the ethical, social, and legal implications of what we do. So consider that as you go through, because ethically, it's responsibility consent. It's not single to yourself. Now we talk about health records. And you can see there on the left-hand side that a health record is any relevant record made by you at any time of the consultation or subsequent to the consultation or at any other time. And when you think about your health record, remember POPI. the Protection of Personal Information Act, which is now fully enforced as of 18th of September last year, and all of us have to be compliant with by the 1st of July this year. When we talk about our medical records, I want to split this into two pieces of discussion. In this first piece on this slide, I want to say that your clinical record includes all your descriptions of physical findings. Now, this is a case that came up, AM and another versus the MSc of Health in the Western Cape, which was reported last year, was about a young child. And the young child went, now this is public record, so I'm sharing this openly, and you can reference it and read it yourself. But this is about a young child who falls down on the stairs, carpeted stairs at home, goes in several hours later to the emergency room with a swelling behind their ear. They were triaged. They were seen by the practitioner on duty, who turns out, by not only her own judgment, but by the judgment of peers and colleagues as well. I'm just looking here. The question is, it is not generally known, but there are specific consent forms prescribed by law to be used for consent when the patient is a minor. So, true story that there are consent forms. There are requirements for a minor that you need to in terms of consent and in terms of disclosure that you need to do. We're going to talk about that a little bit later. In terms of disclosure, you need to, as a clinician, get consent in writing for the disclosure of information. But consent forms are procedure specific for minors and for people in the majority, minor being under the age of 18 and in majority being over the age of 18. So in this case, what came out of this entire journey was that the judgment was this: the cold words of the record is the only factual basis that the court has to ascertain the accuracy and the detail of the examination and the results and findings which inform the diagnostic option and subsequent treatment plan. Now, I happen to have a deep empathy for the two sets of experts who gave evidence on both sides. It came down to the question of whether the bump on the child's head was soft and spongy or firm. And one of the experts made the statement, if it's not there, it wasn't done. Now, maybe you did it. Maybe you were thorough. But if it wasn't there, it wasn't done. If it's not in your records, the courts will assume you didn't do it. Now, in this case, the reason that it was firm versus spongy form was because it turned out to be a linear fracture, turned out to be a bleed, and the child by the next day was profoundly palsied and has a significant long-term impairment as a consequence. But it couldn't have been known at the time of the investigation that was the sequela that would play itself out. So your records need to be comprehensive. And I say that going into the next slide, that says any relevant record, relevant being the key word, is considered to be a health record. Now, a health record, in terms of the requirements, it contains the information about the health of an identifiable individual. It can be a handwritten contemporaneous note, and now it can include digital records. That's why I asked you earlier. I spoke to a colleague who said, you will have to pry my pen from my cold, dead fingers before I start doing notes in electronic format. I've got no pressure either way, but understand that you've got to keep records for a particular period of time. So if your records are destroyed, and this is a minor, you have to keep them to majority plus several years. And we'll go through that in a little while. If they are a person who is mentally impaired, you have to keep it forever. And if they're a person in terms of an occupational health injury, you have to keep it for 20 years. So bear in mind that these complexities are there. Your health record includes notes taken by previous practitioners, attending healthcare or other healthcare practitioners, including discharge summaries. Referral letters are included as health records. So are your laboratory results, automated analyzers, x-rays, reports, and traces. So we call them x-ray films because back in the day, I mean, if you think about it, the Roentgen who won the Nobel Prize for X-rays, X meaning I don't know what the radiation is at the time. That was in 1901. And the X-ray was only popularized in 1904. So we think about how far we've come from an X-ray film that you needed to keep with a viewing box on your desk to where you can now log on using your laptop or your tablet, and you can view in real time not only the report from the radiologist, but you can also view the imaging, and you can lighten it and darken it and rotate it. So the world has changed, but the ability to recall those records still persists. So it also includes any audiovisual records, and there's a lot of movement now for patients to record your consultation with them. Now, my question to you is, why do you not record your consultations with your patient? Disclose to them that you're recording and keep digital records of your consultations. There's nothing saying you can't. There's nothing saying that your record only has to be a handwritten record. If you're doing clinical research or any other forms, insurance forms, disability assessments, injury on duty assessments, and of course, death certificates and autopsy reports all fall part of medical records. So you need to be aware of the following things. You need to keep these records for a couple of reasons. To further the diagnosis or ongoing clinical management. How often do you conduct clinical audits? How often do you participate in teaching and research? And you may have an M&M meeting. You may have a group who meets together on a regular basis. When I was still working at Constantiaberg Hospital, they used to meet once a month and go through interesting cases together. Are there reference or resources that can be recommended to best develop and update consent forms for mental health care practitioners? There are a couple. And what we can do is I'm happy to share with you offline a couple of different resources. There are several subscription services where you can subscribe based on your specialty or based on your practice to a updated consent form repository or library that you can use. So there are many of those. You can also go, many of your associations will have those relationships too. So those of you that want to contact us afterwards, I'm happy to share them with the group, and I'm happy to share them through ASSA with yourselves. So importantly for us, for this, not only for the issues of teaching and clinical trials and diagnosis, but also, and I suppose to some extent, to keep as direct evidence for litigation or for occupational disease or injury compensation purposes. Those are the legal and litigation purposes, but to be kept for historical purposes, to promote good practice, to make case review possible, serve as a basis for accreditation, are all reasons to keep your records. I think the biggest challenge that we have is, are we working together and collaborating to ensure quality improvement? And we can only do that if we have records and if those records are comprehensive. So if you're amending a record, you need to at least have the following information for every patient. You need to make sure that you've got the patient's particular information, their biopsychosocial history, allergies, idiosyncrasies. Now, I used to get into a lot of trouble. I don't know about you, but I would have my file with me and a patient could come in and I would say, "Hey, Trevor, it's so good to see you. How have you been? How are the kids? How's your family? How's that golf swing of yours if you're a golf fan?" And then I'd see them out in a social environment or in a shopping center or somewhere else. And I couldn't remember who they were because the notes were kept in my file, not in my brain. And that's a challenge. It's also a challenge if you get challenged on this in a court and they say, "Oh, you remember what you did with that patient 5 years ago at 10:15 in the morning?" You say, "Yes." You say, "Well, what did you have for lunch 3 weeks ago on Tuesday?" You say, "Well, I can't remember." So, "Well, if you can't remember what you had for lunch, how do you remember what you did with that patient at that time?" So your time, date, and place of every consultation needs to be recorded. Your assessment of a patient's condition needs to be recorded, plus your proposed clinical management. Plus, and even these days, I lecture on the WHO medication safety protocol across SADC, and I'm still stunned to see how badly we manage our medication and dosage. So those are things to bear in mind. Trevor says his golf is lousy. So we go on and we say healthcare practitioners should enter and maintain also the detail of referral to specialists, the patient's reactions to treatment. Now, one of the things, and I use medication as an example, is every time you start a new medication with your patient or you modify their regime, are you calling them the next day to see their reaction and record their reaction? Because it's one of the WHO's 5 steps of medication safety. If you're not following up with your patient, you're doing an error by omission, you're leaving it out. And then you should also have your test results, your imaging and investigation, your information of when or not a patient was booked off work because you've got issues for that. And of course, your proof of consent. Now, we spoke about retaining records earlier. Records should be retained for a minimum of 6 years after they become dormant. In other words, after you finish treating that patient. Minors and patients who are mentally incompetent should be kept for longer. For minors, it's up until their 21st birthday. And if they are mentally incapable people, forever. In terms of occupational health and safety, they need to be kept for 20 years after treatment is concluded. So you've got significant amounts of time that you need to be able to keep records for. So access to records, you have to provide any person over the age of 12 and older with a copy or abstract or direct access to their records regarding their medical treatment on request, and that is written request. So that's also contained in the Children's Act. So this goes back to the question that was asked earlier, where the patient is under the age of 16, the parent or legal guardian may make the application for access to the records, but access can only be given on proof of receipt of written authorization by the patient. So not only does the parent have to ask, but the patient has to agree, and that's contained in the Access to Information Act. So there's a lot of literature that supports how you give information to whom at what time. And when we go back to the beginning, when I said to you, what is your standard operating procedure for your practice? Your policy for how you give out information and to whom becomes really important. So here's an 8-point revision for your clinical notes. And then we're going to do a little on disclosure. We're going to wrap up with 2 or 3 minutes to go. Your record should be complete but concise. You don't have to have a huge narrative, but keep the key things in there. Make sure that it is consistent. Make sure that it is in a standardized format. If you're doing alterations, they must be a strike through in pen, signed and dated, so that the old entry can be seen and the new entry is there. You should only be giving out records with proper authorization. You need to understand that billing records are separate from patient care records, but both need permission. And all your attached documents should be labeled. They shouldn't be left free. Also bear in mind that you should avoid and be careful about making disparaging remarks in your records, because sometimes people see this and that can often create awkward and uncomfortable moments. So in terms of disclosure, what you share, you need to be aware that this is booklet 5 of the Health Professions Council on protecting and providing information. There are times when you will need to provide information. You have to make sure that when you provide information, you're doing it on the appropriate platform. I got a WhatsApp today where the person said, here's the plain film x-ray. Here's the patient's issues. As a second opinion, what do I think? My first answer was, does the patient know you shared this with me? Do they know you've shared this with me on a social media platform? So you need to understand that the use of social media may lead to improper disclosure. And it doesn't mean that you're intentionally doing it, but you need to make the patients aware that their information is going to be shared with a healthcare team. You also need to share with them reasonably, and I say this word gently, that there's good communication and that what will be shared is appropriate, but that the patient wouldn't necessarily be identified through this. There are times where you as a practitioner have a contractual obligation to a third party. You're doing a medico-legal review, or you're doing a injury review, or you're doing a competency assessment on behalf of an employer or an insurer. And the patient needs to understand that the report that you're generating is being paid for by a party, not them. And so the record goes to the party and not to them. You've also got to be aware, as we wrap up this discussion, that disclosure in public interest is something that your patients need to understand. They need to understand that if you identify something that is a notifiable disease, you need to be able to share that information with the NICD or with the necessary Department of Health body to allow this to happen. And then finally, and we've spoken about this, in terms of treating minor patients, you need to be aware that both parents will need to be consulted with, regardless of which parent consents to treatment, because there are times, and we're seeing this increasingly, where the two parents will fight their custody battle through your practice, and then inadvertently you're caught in a position that you don't want to be in. So I committed to finish before 7 o'clock, and I think we're at 3 or 4 minutes to 7 now. So I want to thank you very much and open this, handing it back, Professor, potentially to yourself and Trevor and MJ. So I'm here to answer any questions that you have.
Thank you very much. That was extremely informative and fascinating. I wonder if we have any questions. I can't see any hands up.
Brad, I've got a question for you.
Of course, Trevor.
If you had your medical malpractice insurance with Blackstone and Genoa, are you on our panel that assists when our clinicians find themselves in difficulty?
It is my day job. When I'm not seeing patients in my own practice, I'm supporting the internal attorneys and medical legal team of Genoa. And
for that, I thank you, Brad. It's really cool, and I'm just very comfortable with what we offer to our clinicians and the guys that are on this webinar tonight.
I can't see any hands up, so I'm going to ask a question. I've got one. Baya.
Of course, please.
Hey, how are you? Hello? Can you hear me?
Yes, we can.
Okay. I'm working in a particular situation in a trauma unit when we usually receive patients who come in unconscious post car accident or any trauma. And the difficulty I usually get is the one that to get consent when the patient is unconscious. And usually we usually call the clinical manager or whoever who is the superintendent on call to get consent from them. I would like to know, I'd like to have a comment from you, from your point of view. Is that a correct practice to do? Or do we need still to get consent from family when we know that most of the time we don't have much time to manage this kind of patients? Sometimes they need to go straight to theater or straight to ICU or to be transferred to another hospital quite quickly. What do you advise in those cases?
So that's always a really difficult place to find yourself. So I'm going to point you back early in the presentation to section 6 and 7 of the National Health Act. It says you need to get consent in all instances except when there is an emergency and when your actions are life-saving. So if there's imminent death or permanent risk of impairment as a consequence of your inaction, then you need to act. And I think the issue that you need to have here within your trauma unit, within your ER, and within the facility that you work in, you should have a standard operating procedure that says when the patient is unconscious and severely compromised, our acts of triage and stabilization will extend to life-saving actions only. If you're going to decide what needs to happen post-life-saving, when we get back into life-enhancing, once the patient has been stabilized and once they are normalized and hemostatically back where they need to be, that's a whole different discussion. But to answer your question very specifically, your actions, as long as they documented appropriately, to say that there was no band on the patient's wrist, there was no family member present, there was no mechanism to call people, or there was a time sensitivity. So we acted in a manner consistent with Section 6 and 7 of the Act to allow us to do heroic actions, then you're okay. If you're in there and you say, gosh, we should really remove this person's appendix at the same time, probably you're in an area that's less good. But if you're doing trauma, especially MVA and roadside, you have a mandate to act to preserve life.
Thank you. Are there any other questions? I have one for you. It seems in practice, the consent form is often signed by the nurse in the hospital and not by the doctor, countersigned by the nurse in the hospital. So the nurse seems quite often to actually be signing the consent document. That was the one thing. The second thing is that increasingly doing consent takes longer and longer time. It takes an enormous amount of time to talk to the patient, talk to the family in a busy practice. How do you manage that? There's two questions.
Yeah, I'm going to take the theory approach, and I'll share with you in one of our other conversations that we're going to have the story of a general surgeon who talks about the risk of a high volume practice and how it led to a clamping of a femoral artery that led to the loss of a lower limb of a patient he was doing a hernia repair on. And the lesson that was learned is the time taken to do an appropriate consent is much less than the time taken to build a defense to justify why you made an error. Now, if you're seeing patients on the half hour, you need to do that on the 45 minutes. And I've had colleagues say to me, Brad, this is great in theory, but the risk of doing a comprehensive consent and keeping records versus the economics of seeing one patient less an hour, I'd rather see more patients. And I say, no problem. Understand that in the off chance that your volume leads to a complication that somebody takes exception to, we will not be able to adequately defend you because you won't have the right documents in place. It means that you'll both be wrongful and negligent in the current climate is what you weigh up. So my answer to everyone is, in the perfect world, when I started in practice in the early 90s, the concept of consent was, are you happy to see me? They say, yes. You say, great, let's go in and let's do our consultation. Nowadays, it's a lot more complex than that. And there needs to be a lot more rehearsal about what you say. A lot of the general consent content can be shared with the patient for them to review and read prior to them coming in. And if you are doing a specific type of procedure with them, they can review those procedures on YouTube or on your website or somewhere else, so that by the time they come in, they've had the opportunity to formulate questions and they're not seeing it for the first time. I do think that this is difficult because we don't want to reduce patient time. We do want to have a certain amount of patients that we see on a volume basis because we've got debt and we've got financial obligations. But for each person, their appetite for how much time they're willing to spend on a consultation will differ. So the short answer is ethically, it sounds perfect to say, take all the time you need. Practically, it's not always like that, and you've got to find the balance for yourself.
Good evening, Brett. May I ask a question?
Please.
Yes, I'm Dr. Fuzani. My question is relating to A&E cases where somebody comes intoxicated with a serious injury, but they're refusing treatment. How far should you go as a practitioner in convincing this particular patient to accept your treatment, or in making him sign an RHT?
The difficulty with a person who's intoxicated is they don't have capacity. Otherwise, we wouldn't call it intoxication, right? So they're a person who's come in with diminished capacity. Notwithstanding that, they still have their rights to refuse care. You have to make a clinical judgment call as to whether withholding care will put them in a position where they or others will be at significant risk. So there's a great statement called AMA, where you say, I'm releasing you AMA. AMA is without medical, against medical advice, but it doesn't change your obligations to act as the reasonable practitioner. So if you're in the A&E and somebody comes in and they're intoxicated and they refuse care, the best that you can do is strongly promote why care is necessary. If they leave, you have to be able to record this person refused care and left. But you can then follow up with them in a reasonable period of time, make sure that you get their contact details and have people follow up and say, what happened? Now that you're sober and it's the clear light of day, and I say this because my sister-in-law did her anesthesiology at Barra, and she said when there was a football match, you kind of hope that the home team lost, because there was less violence amongst the supporters of the home team because they got less drunk. The team that won always got more drunk and ended up in the ER. So I don't have an easy answer for you. You have to look at it on a case-by-case basis. But I can tell you, having a patient sign something when they're intoxicated won't give you any defense if there's recourse.
Thank you so much, Brett. Thanks.
Sorry, I couldn't give you a better answer. I see there's other questions. It comes from Galaxy Note 20.
Okay, thank you so much for the opportunity. I'm Jimmy, not Galaxy Note 20. Okay, so I wanted to come back on the answer you give when someone is intoxicated and give if you take a consent for that person. It's for me, I always find like it's very difficult for those patients who are very intoxicated, because it's sometimes difficult to make a difference between their confusion or their aggressivity is due to maybe loss of blood or bleeding in the brain, or due to the alcohol intoxication. So I don't know your uptake on that, because it's quite a bit tricky. So should you leave that patient go home or leave the hospital and then the patient collapse on the gate because they've been bleeding in the chest or in the abdomen? So what should be, how can I put it? I don't know if you get what I mean.
I know. Let me try and say it back to you.
Yeah.
The patient is behaving erratically because they've got a subdural hematoma or the fifth beer in their stomach. Which one is it?
So you find a patient who's like misbehaving and smelling completely alcohol. He's drunk, but you don't know whether that behave is due to subdural hematoma or to the alcohol. And you decide now, the patient decide not to receive your treatment. And the patient signed RHC and went to the gate. And then by the time he arrived to the gate and collapsed, and then later realized that he had a subdural hematoma.
So possibly in circumstances like that, and they're few and far between, but they do exist.
Mm-hmm.
There are more than one or two diagnostic tools that you can use to assess what exactly is going on with that patient neurologically. Palpation of the abdomen will tell you whether there's a profound sensitivity and whether they're bleeding internally or whether they're just too drunk. So I don't know the easy answer. You would have to look at each case on a case-by-case basis. You would also need to be able to say, can you realistically test? Do you have a breathalyzer at the hospital? Because maybe what you need to do is breathalyze the patient. And this is not a recommendation, it's an observation. We did this for one of the large employer groups that I worked with. We would breathalyze the person and we would say, gosh, you're doing pretty well there on your breathalyzer. Maybe what you should do is just have a quiet sit for 30 minutes. Just relax, here's something to eat or drink, or here's a glass of water, and observe them and have a nurse just keep an eye on them. That would give you a sense within 30 minutes if they have a neurological deficit, or if they are decompensating, or if they are moving back towards sobriety. I think being able to keep them in a still environment where you can monitor them for a period of time, even if it's in the ER in a corner on a chair, may give you a better outcome.
Yeah, thank you so much. Yeah.
We have
thank you. Yeah.
Pleasure, my pleasure. I see we have a few more questions coming through.
We do have another hand up. Do you want to take that first, Brad?
Yeah, absolutely. I'm guided by
Tanzania, you can go ahead.
Thank you. Just on the issue of the consent, if you're managing children, you mentioned that one needs to engage both parents. So how does one go about this issue? Say a child is brought to the hospital by a single parent or by one of the parents, and they happen not to speak to each other. Where do I get the contact for the father in that case, as an example? Thank you.
This is the one question that recently has kept me up a lot, because I've been involved in several matters like this in the last few months. I think in the first instance, getting the consent from the caregiver, the parent who presents, is probably the most important thing that you can do at the moment. If you ask the parent, and these are the questions you would ask, is you would say, are you and your husband married? If they say yes, then you're okay, by and large. If they say no, my husband and I are divorced, or my wife and I are divorced, then you have to say, well, what kind of procedure am I doing? If this is a procedure that substantially changes the child's life, you then need to say, I would like to have your ex-spouse's number so that I can let them know what's going on, so that everyone is aware. If they say absolutely not, and the timing is such that there's an urgency, you make a note in your clinical notes that says, met with the parent, Brad Byra, requested consent from the wife of Brad Byra, was informed they're divorced, Brad refused to give number of his wife, urgent care was needed, and care was undertaken. And then at least you've date and timestamp that you've made the reasonable effort and you've met the reasonable person test to get consent. It's different in an emergency situation, like when there's a acute presentation in the OPD or in the A&E, to when you're doing an elective procedure where there's plenty of time. So let's separate the two out. When you're in the A&E, or when there's an OPD matter, or when there's a crisis, you take the consent from the presenting person who's able to give it, plus the minor. If you are doing an elective and it's not urgent, then more effort should be taken to get the consent of both parents. The second part is, what is the fundamental difference between consent and power of attorney, especially if you're in an independent case manager without necessary regulated scope of practice? Power of attorney is what an adult would give to another party to make decisions on their behalf. So I may give the power of attorney to my attorney, or I might give it to somebody who would represent me in the event that I can't represent myself. Like an advance directive that says, do not resuscitate. Consent is different from that. In the power of attorney is a form of consent in extreme circumstances where I'm not able to give consent for myself and there's no one else to give consent. So preempting, for example, if I decide I want to have a do not resuscitate, I would have a bracelet that says do not resuscitate. so that whoever the first responder could see that. But that would also need to be followed up where my emergency contact person says, yes, I'm aware that there is a do not resuscitate, do not resuscitate. That would act as consent and power of attorney. Generally, they're different. Consent should be taken first from the individual, and where not, from immediate family or given by the court. Power of attorney is a preemptive statement for that. So I hope I've answered that question for you as well.